Ready, start. Applying the law laid down by this court in the aforesaid decisions and considering the scope of inquiry at the stage of framing of the charge under sections 227/228 CRPC, we are of the opinion that the submissions made by the learned counsel appearing on behalf of the appellant on merits, at this stage, are not required to be considered. Full stop. Whatever submissions are made by the learned counsel appearing on behalf of the appellant or on merits are required to be dealt with and considered at an appropriate stage during the course of the trial. Full stop. Some of the submissions may be considered to be the defense of the accused. Full stop. Some of the submissions made by the learned counsel appearing on behalf of the appellant on the conduct of the victim/prosecutrix are required to be dealt with and considered at an appropriate stage during the trial. Full stop. The same are not required to be considered at this stage of framing of the charge. Full stop. On considering the material on record, we are of the opinion that there is more than a prima facie case against the accused for which he is required to be tried. Full stop. There is sufficient ample material against the accused, and therefore the learned trial court has rightly framed the charge against the accused, and the same is rightly confirmed by the High Court. Full stop. No interference of this court is called for. Full stop. In view of the above and for the reasons stated above, the present appeal fails, and as a result the appeal stands dismissed. Full stop. Considering the fact that the allegations against the appellant of sexual abuse are very serious and affecting the dignity of a woman, and is the most morally and physically reprehensible crime in a society, an assault on the mind and privacy of the victim, and the trial for such offences is required to be decided and disposed of at the earliest, and considering the fact that in the present case the learned trial court has framed the charge against the accused, and the incident is of 2013 and there is already a delay in concluding the trial because of the pending proceedings, we direct the learned trial court to conclude the trial at the earliest within a period of 6 months from the date of receipt of the order of this court. Full stop. All concerned are directed to cooperate with the trial court in the earlier disposal of the trial and within the stipulated time observed herein above. Full stop. It is settled principle of law that at the stage of considering an application for discharge, the court must proceed on an assumption that the material which has been brought on record by the prosecution is true, and evaluate such material in order to determine whether the facts emerging from the material taken on its face value, disclose the existence of the ingredients necessary of the offence alleged. Full stop. We have bestowed our consideration to the rival submissions, and the submissions made by Mr. Ranjit Kumar commend us. Full stop. True it is that at the time of consideration of the applications for discharge, the court cannot act as a mouthpiece of the prosecution or act as a post office, and may sift evidence in order to find out whether or not the allegations made are groundless so as to pass an order of discharge. Full stop. It is right that at the stage of consideration of an application for discharge, the court has to proceed with an assumption that the materials brought on record by the prosecution are true, and evaluate the said materials and documents with a view to find out whether the facts emerging therefrom taken at their face value disclose the existence of all the ingredients constituting the alleged offence. Full stop. At this stage, probative value of the materials has to be gone into, and the court is not expected to go deep into the matter and hold that the materials would not warrant a conviction. Full stop. In our opinion, what needs to be considered is whether there is a ground for presuming that the offence has been committed, and not whether a ground for convicting the accused has been made out. Full stop. To put it differently, if the court thinks that the accused might have committed the offence on the basis of the materials on record on its probative value, it can frame the charge, though for conviction, the court has to come to the conclusion that the accused has committed the offence. Full stop. The law does not permit a mini trial at this stage. Full stop. The defence of the accused is not to be looked into at the stage when the accused seeks to be discharged. full stop. The expression double inverted comma the record of the case double inverted comma clause used in section 227 CRPC is to be understood as the documents and articles comma if any comma produced by the prosecution, full stop. The code does not give any right to the accused to produce any document at the stage of framing of the charge, full stop. The submission of the accused is to be confined to the material produced by the investigating agency, full stop.